The Honourable Leanne Dalzell.
Chairman, I do want to take an opportunity to take a further call due to the Minister who's now in the chair, because as the other Minister responsible in this area of the legislation, I felt that it was really important that I asked him to take the opportunity to respond to whether he now thinks it's a good idea to have the regulatory impact statement separate from the bill itself, because this regulatory impact statement, which is totally relevant to both the title and the commencement date, because both of these issues are touched on in the regulatory impact statement, this is a very, very clear example of why we actually need to have the regulatory impact statement included with the bill itself. Now, on this particular occasion, as I've discovered subsequently, the regulatory impact statements are being required to be tabled by the Bill's Office, essentially because we're an urgency and some MPs won't have time to go back to their offices and download it from the Treasury website before the bill is actually debated in the House. But I actually have to say that this is entirely unsatisfactory and wouldn't have arisen as an issue if the Minister hadn't been so demanding of having them removed from the bills themselves. And I've never actually heard the Minister explain why he had this decision taken to Cabinet, because it's such a detrimental approach. And perhaps, I don't know if the Minister's read the regulatory impact statement for this bill, but the one that really concerned me, and I thought would have concerned him, was in the proposals to replace the elected councillors for all of ECAN's functions, which is what the title of the bill is all about, suspend local body elections and removing the right of appeal on the NRRP or water conservation orders except on points of laws. The departments themselves said these proposals appear to present a prima facie access to justice issue, and some departments were concerned that this may not be consistent with the government's statement on regulation, better regulation, less regulation, which requires a strong case to be made for any regulatory proposals that are likely to override fundamental common law principles. This bill overrides fundamental common law principles, and the Minister's silent on it, and it certainly doesn't say that in the title. It says Environment Canterbury Temporary Commissioners and Improved Water Management Act 2010, which doesn't actually indicate that many people had concerns that there was an overriding of fundamental common law principles. I'm finding a point of order, Mr Speaker.
Point of order, the Honourable Leanne Dalzell.
Well, the Minister whose name the bill was in is back in the House, and I thought that it was a requirement that he sit in the chair when he was in the House.
The Minister can decide who sits in the chair at the time. The Minister has come back to retrieve some papers, but if the Minister intends staying, then he needs to be sitting here.
That's right. Thank you, Mr Chairman. Thank you, Mr Chairman. The point that I wanted the Minister to respond to, who's in the chair, is this question of the impact of the kind of decision-making that has led to this being called the Environment Canterbury Temporary Commissioners and Improved Water Management Act, and of course the commencement date. The commencement date bothers me a lot because it talks about the Act coming into force on the day after the date on which it receives the royal assent. But what we heard from the Minister yesterday was that in fact this is expected to be done and dusted by the 1st of May. Well, do you know what the implementation date was in the regulatory impact statement? 1st of April, April Fool's Day. That was the original date that they had actually planned to have this come into effect, not the 1st of May. So we're actually an entire month out from the original plan, and in fact this was supposed to happen on the 15th of March. What's the date today? Oh, it's the 30th of March. Oh no, actually it's the 31st of March everywhere else in New Zealand except here in Parliament, because of the irony or the process of urgency somehow makes that clock stop, and it has stopped on the 30th. But the 15th of March was the date that the government was supposed to be progressing this legislation through Parliament according to the regulatory impact statement. Now this is what bothers me, is that the regulatory impact statement should be an integral part of the debate on this legislation. It is absolutely fundamental, and none of the stuff that we have discovered by reading the regulatory impact statement was mentioned in either of the Minister's speeches or any of the government speeches on this bill, and we really haven't had a proper debate on the elements of the bill that actually mattered. Well, the other thing that perhaps the Honourable Rodney Hyde might like to hear from the regulatory impact statement is this. Options that rely on introducing legislation in a very short time frame increase the risk of poor or misdirected intervention, resulting in unintended consequences and the need for subsequent intervention to remedy these consequences. That's exactly what's wrong with this process. It is not a robust process and there will be a price to pay.
The Honourable Rodney Hyde.
Thank you, Mr Chairman, and I'm very happy to reply to the